software not honoring user boundaries.
That was
and I'm
me.
wondering if there's any litigation action or other motions in place to try and convince or compel forensic software vendors and or manufacturers and or investigators to be put in a position where they must honor user boundaries.
Yeah, I mean, to me it seems shocking. For those who weren't in the talk, I was mentioning how in this one case about somebody who gave consent for a search they didn't actually have consent to do, and the FBI was technologically able to do it because NCASE doesn't respect accounts on the computer, not encryption, but just accounts. And I was saying how that made me mad. And the question is, is there any pressure on vendors to do it differently? And I think the pressure on vendors to do it differently would be if the law required you to do it differently. So the biggest case out there that's pushing to require law enforcement to do computer searches differently is United States versus Comprehensive Drug Testing, which is a case in the Ninth Circuit. And that case arises out of these very egregious facts surrounding the Balco steroids investigation. The investigators had some reason to suspect and investigate some number of ball players. You guys, maybe, does anybody here watch sports? Barry Bonds and that whole thing. And they had some reason to investigate some of those people, but what they did was they used a multitude of efforts of using search warrants and subpoenas to get whole directories, spreadsheets of thousands of athletes and all of their drug tests from a company that did the blood work on these things. And the courts were understandably annoyed that the government had turned an investigation of 10 or 14 people into a fishing expedition that got private data about thousands of individuals. And so what the Ninth Circuit did, as the case kind of wound up its way up, the Ninth Circuit tried to issue some rules to prevent this kind of abuse from happening again. And one of the rules was that you can only search for things you have probable cause to search for. Duh, and it's like, okay, it seems like what the Fourth Amendment's about, but they said, you have to have a search protocol that's designed to get you the things for which you have probable cause and not designed to get you the other stuff. And that you should have the forensics done by either an internal team or by an external forensic, third party, and where they're going to look for the right stuff, and then all the other stuff that they might happen to turn up, they're going to just throw that away and not give that over to the investigative team. Some rules are to try to deal with the fact that computer data is always going to be intermingled with private stuff. More than in any other kinds of searches or seizures that we've had before. And how do we keep the private stuff still private while allowing law enforcement access to the stuff that they're entitled to have access to when they have good cause for it? And comprehensive drug testing is anathema to the government. They hate it. Other jurisdictions have considered whether or not to adopt it and have generally not so far, although it's kind of wending its way through the courts. And I think what we're going to see, though, is as those rules sort of get pushed forward and as we try to make case law that says that you have to do these things, the vendors are going to not want to sell software that violates the Fourth Amendment because the investigators don't want to get their cases kicked out for suppression reasons, and that's going to inspire there to be better search tools and more and better forensic tools that adhere more closely to what I think our reasonable expectation of privacy is with regards to these vast repositories of intermingled data. Yes?
So I know that the EFF is about effecting change through legal action and not really getting into the lobbying side of legislation. And I certainly support you financially, and I hope that most of the audience here will support you financially.
Thank you.
What I'm asking is, how else can we affect change in policy, in government, in legislation? Do you have any kind of recommendations for other actions we can take other than online petitions or writing your senator or congressman, which really doesn't seem to get any kind of results? Is there any advice you can give to the audience to how we can affect policy and change in the government?
Well, I'd first like to take issue with, thank you for the question, but it actually does make a difference when your senators and congresspeople hear from you. We ultimately failed to stop Congress from passing an immunity for the phone companies that assist in the NSA's warrantless surveillance program, for example, but we held it off for nearly 2 years, and that is almost solely due to the fact that ordinary Americans were pissed off about it and thought that it was wrong and wanted their congresspeople and their senators to maintain the rule of law. So I don't ever want to minimize the importance of your leaders hearing what you, the people, actually think, because it makes a huge difference. In terms of what else you can do,
well, I mean, along these lines, we have something called the Action Center, action.eff.org. And this is where we ask our members to take action on various issues. And yes, sometimes it is saying, please write to your senator or Congress critter and express some views or some such. But that is our best way of trying to organize the power of our membership, where thousands and thousands of people are part of the Action Center, and by making concerted action, that can help some. Otherwise, keeping aware of the issues and following it so that you can tell your friends about these issues and spread the word, blog about issues and use online tools to keep people informed about it, and that can help more people take action, and hopefully we can get good change as a result.
I also wanted to add, some of y'all already heard this from Chris Connolly of the ACLU at his Facebook talk, but there are certainly opportunities for you guys to build things that help educate and agitate. He was talking about people coding Facebook applications or bookmarklets or other things that educated people about how Facebook was using their data, or helped them evaluate whether their privacy settings were good, or helped them scrape out their private data so they could move it somewhere else that better respected privacy. So certainly you guys should be thinking about what are things we can build to affect change. I'm just a lawyer, I can't build things, I can go and talk, but you guys can build stuff. And that is a great power.
Thanks for the question. That's great. Other questions, or that's it? Do you guys have anything that we didn't talk about today that you'd like to talk about a little bit?
I figured since this is an audience that definitely cares about it, considering how well our NSA t-shirts sell here, yeah. I did want to give you guys an update on the NSA lawsuits. It's been a rough year in terms of holding the NSA and AT&T accountable. As I mentioned earlier, there was a law passed back in the summer of 2008, the FISA Amendments Act, and that included purported immunity for companies that had helped with this warrantless wiretapping program, the full scope of which the government still has not admitted. And it basically gave the Attorney General the power to file a secret certification with the court in those cases saying either, I think the program was legal, or even if it wasn't, the president authorized it, or it didn't happen. And the court has to dismiss under this statute. We've argued, and we did argue at the district court when the Attorney General filed this certification, that this was unconstitutional for a variety of reasons, but mostly because Congress was unconstitutionally delegating to the Attorney General the power to decide what the law is in these cases. But our case against AT&T and all the other carrier cases were dismissed. We are continuing to fight that. We are on appeal at the Ninth Circuit right now, just finished the briefing, and we're awaiting a scheduling of oral argument in those cases. As for our second NSA case brought directly against the government, that's Joule v. NSA, our judge zigged when we thought he was going to zag. We had done really well in the AT&T case when it came to the government's argument that, sorry, but judges can't litigate whether this was legal because everything about it is a state secret, and any discussion of it would harm national security. We had won on that issue, and the court had allowed us to proceed in the AT&T case before this immunity passed. The government made the same arguments in the government case, and we were hoping for a similar opinion. Instead, our judge dismissed our case on a rationale that the government never argued, that never came up in oral argument or in the briefing that came after argument. And it's a pretty, with all due respect to the court, pretty crazy idea, which is, you may have heard of something called taxpayer suits, where people try to challenge government conduct based on their standing as taxpayers. So if you thought the Iraq war was illegal, and you brought a case in court saying, well, my money is being spent on that war, and therefore I have standing to challenge it in court, the courts disfavor those. And those are called, in the law, generalized grievances. You don't have any special interest in stopping the war as a taxpayer differentiated from anyone else. And so the law is, as far as generalized grievances, though, those are better left to the political process and aren't really the domain of the courts. Our judge in the NSA case said, well, you have alleged that this wiretapping program essentially reaches everyone who uses the domestic networks. And so I think that's a generalized grievance, and I'm dismissing your case. And what that means is, so long as the government wiretaps everybody, the courts can never judge whether that's legal or not. We think this is very clearly wrongly decided. Every single one of our plaintiffs has a concrete and individual injury, which is their own communications and their own records were ensnared by this dragnet. And so we are appealing that decision as well. There was a little rejiggering of the schedule such that our opening brief to the Ninth Circuit is going to be filed next week. So we are continuing our fight in terms of the NSA warrantless wiretapping program, and both of the cases are before the Ninth Circuit right now. So for those who were wondering.
Question?
I'd like some commentary on the EFF initiative in Australia, looking at the blocking list, the blacklist that the Australian government's considering, and if you've got awareness of the EFF, they're the major spokesman that is arguing against it and pointing out the technical and ethical issues with that particular initiative, and also any other large international initiatives that the EFF has been involved with around the world.
Can you talk about the blacklist?
So unfortunately, we have 3 people on our international team, but none of whom are actually at DEFCON this year. So we are active on international issues in this 3-person team. We have the rest of EFF is mostly focused on the United States, and we have a small team there, but they are working all the time, flying around the world to try and promote digital freedom. I believe that I have heard, through talking to them that about this blacklist, but I don't have enough information on it to give a really intelligible answer. But I mean, one of the things that we do try and do internationally is work to promote good policies and talk to the appropriate policy-making groups like the EU and the Organization for Security and Cooperation in Europe, in the Internet Governance Forum, and this group is very active. They're also very active on intellectual property issues through UN-chartered organizations like WIPO. But unfortunately, I don't have specific information about that particular block list.
Are you talking about the ACTA 3 strikes thing?
No.
Okay.
Well, I can briefly describe it. The current government in Australia is considering a secret blacklist of URLs. The major rationale is child pornography, and obviously, and the problem is beta tests of it had legitimate websites, and its technical actual ability to achieve its stated goal has been seriously questioned, and it raises ethical issues.
Yeah.
Colin Jacobs, the EFF spokesman, is the major person fighting the government in Australia over this issue.
Yeah.
I mean, that raises a point worth clarifying, that there are a variety of electronic frontiers organizations, including Electronic Frontiers Australia, that are not officially affiliated with the Electronic Frontier Foundation. They are our friends and our fellow travelers, but they are not actually officially connected to our organization. So Electronic Frontiers Sweden, or
there's Electronic Frontiers Italy, Electronic Frontiers Finland, Electronic Frontiers Australia. There's a number of these organizations. Just to address some of the larger points, this actually is this has come up in the United States, the notion of having a block list. Sometimes it has been done in the form of URLs, which have not been very efficient in making sure the URLs are all correctly put on there. There was another a proposal that we dealt with a number of years ago, but it was interesting because it was trying to say, well, the URLs keep on changing, so we're going to do it based on IP numbers, but they didn't seem to realize that a number of these IP numbers actually resolve to a wide variety of domains. And so if any one of the domains that was resolving there was on the blacklist, then everything else that was associated with that IP was also being taken down. And here in the States, that was a big